Hi, everybody. Thanks so much for joining us. We said that this court's Friday the 13th order was wrong, and now their almost April Fool's Day order is equally wrong. They certainly haven't budged from where they were on Friday the 13th, despite an awful lot of evidence that we put in about their order creating a set of rules not in play anywhere in Minnesota on Election Day, on the disparate standards used by the different counties that violate the Equal Protection Clause, and by the very words of their own order repeated in this April Fool's Day order, that they will now include votes they call illegal in the count. If these points stand in any final order of the court, it will give us no choice but to appeal that order to the Minnesota Supreme Court. It is unfortunate that the court has taken this tact because it continues to disenfranchise thousands of Minnesotans whose votes should be counted, whose votes would have been counted had they lived in just a different jurisdiction. So we are disappointed, but we feel the court is wrong, and we will appeal. I think with that, I'm happy to answer any questions.
All right, thanks, guys. If you have a question at this time, please press #8. We'll take the questions in the order I receive them. All right,
okay,
first caller,
just to let you know, the host removed you from the queue.
Go ahead. Hello?
Just so you know, the host is on the
identify
line
yourself,
for the time being.
unmute, and then ask your question. Thank you. Next caller, go ahead. Next caller, go ahead. All right.
If you all don't have any questions, that's fine by me.
All right, do you guys have any questions right now? I just unmuted someone, so...
Yeah, this is Bill Werner at MNN. Can you hear me there, Tom?
We can, yes.
Okay, that's good. Is there no chance then, Mr. Ginsberg, that as with the remaining ballots that are in play, that you can plug the gap, that 225 vote gap, and then ultimately you're going to end up appealing?
Well, we haven't analyzed. We don't really know which way these votes will go. It is pretty much of a long shot with that few ballots being put in play, and it does mean that whether there are ballots or not, many Minnesotans will remain disenfranchised who should not be disenfranchised, and so that important principle will live on in an appeal.
How many more ballots beyond the 400 are still in play? I heard a 300, 315 number. Possibly there might be some additional ones brought in. Does that jive with what your count is?
I'm not sure what you're referring to.
Yeah, well, there is still, beyond the 400, there are still some ballots that potentially might be brought in, or is that not correct?
Well, there are the dupe original ballots and the unfindable ballots that supposedly exist in the Minneapolis precinct.
Do you have any idea what that remaining number is then that potentially could be put in play?
No, not precisely.
Okay, but still be a long shot for you folks, even with those brought in your analysis.
Well, the point is the court has reached what we feel is an unprincipled decision that's not sustainable under law. I mean, for the court to impose a set of standards on February 13th that is different from the standards under which ballots were counted on Election Day in all Minnesota's counties and cities, in effect creates a problem with this election that needs to be fixed through an appeal if the court sticks with it.
All right, thanks, Bill. Next question comes from Rachel Statzenberger from the Pioneer Press. Go ahead, Rachel.
Mr. Ginsberg, the court...
You can call me Ben, Rachel.
You once corrected me and made me call you Mr. Ginsberg.
I think that was your excellency I was insisting on.
Yeah. The court made clear that you should have known how detailed a look at absentee ballots they would be taking. And they also made clear that they rejected your call for them to presume that ballots are valid. Did you not understand that during the trial, and could you not have put in more evidence so you could support the centerpiece of your case?
I understand that the court was subsumed with its own logic. However, we were looking at what happened in Minnesota counties on Election Day and mindful that a court, under no circumstances, can invent a different set of rules after the game is played. And so what we did, as the evidence at trial showed, was follow the standards and procedures that were actually used in the counting place by Minnesota election officials on Election Day. Not this sort of parallel universe that the court has set up with its Friday the 13th and almost April Fool's Day rulings.
So then you knew that you would lose very early on.
No, we thought that the court would recognize that those fundamental principles of law and adjust.
And so at what point have you decided that the court wouldn't adjust those fundamental principles, given that they refused to reconsider their February 13th order and that they issued subsequent orders after that regarding the specificity they would
Well,
require absentee ballots?
they actually, in some of the now-in orders, I think, went back on what they'd said on February the 13th. And, in fact, there are some somewhat surprising provisions of this order that I think goes back on it. For example, if you turn to page 17 of their opinion, they say voters overwhelmingly testified that they asked their witnesses whether they were registered voters. Given this testimony and the instructions to the voter, the court accepted the witness as a registered Minnesota voter if the witness gave a Minnesota address and there was no evidence to the contrary concerning the witness's registration status. Now, that is different from where they were on February the 13th when, as you'll recall, and I believe it was on page 14 of that opinion, they said a witness has to be registered, period. Here, they're saying, well, we'll take people's word for it. So that I believe they were impressed with the fact that people were wearing an I voted sticker, although we all know we've seen 7-year-old children whose parents voted and they're wearing the sticker and the kids certainly didn't vote. So our recognition that the court was not going to change came roughly 97 minutes ago when we got the order.
Don Davis from Fargo Forum, you're up. Go ahead, Don, or Scott Wetty.
Yeah, Scott Wetty here.
Come back.
Just to be clear, are you saying that an appeal will be necessary because there's no way that Coleman can win in the state?
I'm saying, Scott, I'm sorry, I'm having problems hearing you because there's wind blowing in the background somewhere.
Okay. Are you saying there's essentially no way, given what the judges have ordered now, for Senator Coleman to prevail?
No, I think you never give up hope, but it becomes a much longer shot. I mean, we were pretty confident with the 1,358 ballots, if they had been opened, that we would have prevailed. The odds get longer this way. It's still a mathematical possibility, but it's probably akin to you winning your NCAA bracket pool at this point.
And you don't anticipate any further action from the.
You know, there'll still be a final opinion, and it is conceivable that there will be other things that happen. But if this is the universe of ballots, and this is their final order, there is still a mathematical possibility, but I mean, it's less.
All right, thanks, Scott. Next question comes from Pat Doyle from the Star Tribune. Go ahead, Pat.
Hi, Ben. You said that you're intending to appeal to the Minnesota Supreme Court. Are you also willing to appeal to federal courts, either the Supreme Court for review or to U.S. District Court, either parallel to a Minnesota Supreme Court bid?
Well, our next step is to the Minnesota Supreme Court, and I think that's all we're prepared to discuss at this point.
All right, thanks, Pat. Next caller, go ahead. Go ahead, next caller.
Yes, I guess could you walk me through the sort of the process of how this appeal would work and what sort of logistically would happen? You know, when you said that there's a sort of a final ruling that's expected from the court before you said things were finalized, and then could you just describe the sort of process after that?
I'm sorry, who is this?
I'm sorry, this is Philip Klein from the American Spectator.
Well, I'm not sure we know precisely the answers to all those questions. I mean, this is what we have before us is an order and a memorandum. Presumably, the court will count the ballots on April the 7th. I think that they will then issue some sort of final opinion, and I suspect that they will do something with numbers for each candidate, although we would note again that they'll be including illegal votes in that count. There are still the unresolved issues that this order doesn't address, which is the dupe original issue and the erstwhile ballots in the Minneapolis precinct. After a final decision or order, Minnesota statutes give you 10 days to file a notice of appeal, and then a period of time after that to file a brief. My guess is that the Minnesota court will come up with some sort of a briefing schedule. I couldn't guess that, and I don't know what this court's schedule is.
All right, thanks. Next caller, go ahead.
Hi, Ben. This is Jay Wiener from MinPost. I can tell you're not happy with the ruling. My question is, do you think that they actually went out of their way to scold your side? For instance, on page 6, where they say each party knew or should have known the scope of the court's review. Did they take some whacks at you that they shouldn't have?
No.
So you're okay with it? Because other than ruling against you, they also seem to say that the Coleman side didn't do its job, or that's one way to read it.
It's not the way I read it, but go ahead if you want to.
But what's your interpretation of those paragraphs on 6 and 7 there, where they sort of outline how this is a follow-up on Rachel's, I guess, that you should have known what they wanted you to do, but you didn't do it, is how I read that. Is that?
Well, I mean, we believe that the court is wrong in their entire standard of review of this process, and we do not believe that a court can come up with its own set of rules months after a game is played, or halfway through our case, for that matter. And I think I gather that we fundamentally disagree with them, and that's why there are appellate courts.
Thanks, Jay. Next question comes from Curtis Gilbert from NPR. Go ahead.
Mr. Ginsberg, you've got this ruling. It's unanimous. It came from 3 judges nominated by governors from 3 different parties. Why not just accept this? What reason would they have to be so unfair to you if that's what you think they're doing?
I'm not sure we just think they're wrong. We think that it is wrong to disenfranchise voters. We think it is fundamentally wrong to sort of sweep the problems of this election under the rug. We think that the rights of voters to have their votes counted is important, and we're going to appeal.
All right, thanks. Next question, I believe, comes from Emily from CQ.
Hi, Mr. Ginsberg. This is Emily today at CQ. I just had a question for you regarding the Supreme Court ruling on certification that came out in February. I was wondering what your interpretation of that was. If Mark Elias and the Franken campaign have interpreted that to mean that after all the state appeals play out, that then the governor is required to certify a winner in the election. How do you guys interpret that ruling, and do you expect there to be a certification after the appeal plays out to the Minnesota Supreme Court?
I believe that what that ruling says is that there absolutely cannot be a certification before the Supreme Court rules, which is a pretty logical thing for the Supreme Court to say. But The question of a certification after that is, I think, an open legal question. Certainly nobody has any precedent on it.
Okay.
All right, thanks, Emily. I'm showing one last question from Rachel Stassenberger from the St. Paul Pioneer Press. Go ahead, Rachel.
Thanks a lot. Ben, you just said it's an open legal question. Is it one that you will be arguing that federal appeal should stop an election certificate?
Well, we suspect that the Minnesota Supreme Court will recognize the wisdom of our position. So, not prepared to answer that at this point.
And then last, you have said repeatedly that this court has disenfranchised Minnesotans. Does the Coleman campaign bear no responsibility for not submitting proper evidence for the valid votes that it thought should be counted? Did you not?
I fundamentally reject the premise of your question.
Okay.
If we did not submit proper evidence, then what you saw in the 7 weeks you sat through the trial was that election day judges in virtually every Minnesota county and city did not ask for proper evidence about the voters whose votes they enfranchised. Now, the fundamental part of this case is that you can't have it both ways. You cannot have one set of rules on election day in which ballots are counted, and then presto magico, on Friday the 13th and almost April Fool's Day, you have another set of rules that says you have to meet all these standards. So the premise of your question, I believe, is wrong.
All right, we'll leave it there. Thank you, everybody.